President Biden told the New York Times that Section 230 should be revoked.
Social media companies that engage in censoring or any political conduct will not be able to keep their liability shield.
Section 230 was the greatest internet policy achievement Congress passed to date.
Section 230 may come under legal attack. It may turn out to be an unconstitutional law that Congress has made.
I am willing to bet all of the money that I don't have that you've heard of Section 230. The 26 words that created the internet has been a hot topic for quite a while now, both with hardcore defenders of its protections and those that believe that it's made companies way too powerful. I feel like there are genuine examples of Section 230 protections being too powerful, especially in regards to how social media companies are protected from the negligence that puts their users in danger. That being said, reading the proposed reforms firsthand, I don't think that the serious problems are properly addressed, and the reforms that do leave a whole other basket of issues in their wake. With that perspective in mind, today we're going to be discussing what Section 230 is, observing 4 independent cases that solidify Section 230 protections and define what they are. We'll also go over 4 proposals that intend to revise these protections, ranging from well-intentioned negligence to idiotic nonsense. These are the imperfections of Section 230 and the proposals that will make things worse. The law that is commonly referred to as Section 230 of the Communications Decency Act is widely considered to be one of the most important laws when it comes to the internet. Let's start this dive with a brief look at the cases that created Section 230. Cubby v. CompuServe was a case that created protections for internet distributors, and the ruling in Stratton Oakmont v. Prodigy Services Co. set the precedent that these protections don't extend to hosts that were considered publishers. In 1996, the Communications Decency Act was passed alongside Section 230, which was created as a response to these cases, giving both distributors and publishers the same protections under the law. Now that we know why the law was created, let's look at the actual text of said law. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So this protection is quite simple. No social media provider is responsible for any of the content that it didn't produce. This protection here also gives the legal right to remove any content that they deem objectionable, whether or not the speech is protected under the Constitution. Now, going a step further, these protections aren't equal to every single website ever in existence. There are some very important exceptions to consider. If a website encourages the violation of criminal law, intellectual property law, state law, or existing communications privacy law, Section 230 protections don't apply. With that being said, let's see these protections in action. If you're looking into a law, amendment, bill, or otherwise that has been passed and want to see how it affects the United States as a whole, a great place to start is by examining the case law in which it was used as a defense. And there's no better place to start than the first case that involves this newfound law. Advertisements for offensive t-shirts that were created in parody of the Oklahoma City bombing of 1995, a tragedy that killed 168 people, including 19 children, made their way across the internet via AOL. These advertisements contained a message that instructed people to call Ken, including Kenneth Zeron's real phone number inside of the ad. He was not involved in the production of these t-shirts. Once he realized what was going on, Kenneth asked AOL to remove the ad and issue a retracted statement, lifting him from guilt. While AOL did eventually remove the offending advertisements, no retraction statement was ever made, so Zeron took AOL to court. Zeron argued that AOL took way too long to remove the advertisement and refused to remove other advertisements that were similarly defamatory. This argument didn't work since AOL was protected under the first portion of Section 230. This case was a landmark in Section 230 protections, shining a light on how powerful these protections really are. That being the case, here is another example of Section 230 being used as a defense for gross negligence. Fair warning, this case involves sexual assault, so if you're watching this and don't want to hear about it, please skip to this timestamp or avert your attention. Matthew Herrick broke up with his boyfriend, Oscar Gutierrez, after Oscar accused him of being a cheater multiple times and harassing him in his workplace. About a week after the breakup, men started showing up at his house, claiming that they were there per Matt's request to commit sexual acts. Over a period of 10 months, over 1,400 men would show up to his house and his place of work, all being promised sex, and being told by the impersonated account that if he resisted, it was all a part of his fantasy. All of these men knew exactly where Matt was, utilizing the geolocating feature that was implemented within the Grindr app. Matt had not had Grindr installed since his relationship first started with Oscar, which was over a year before this incident took place. Along with asking police for assistance on multiple occasions and being denied, he tried to get the account removed from Grindr over 100 times, all to no avail. Matt had had enough. Matt brought Grindr to court. Knowing that Section 230 protections would probably net Grindr an easy win, his representative, Carrie Goldberg, amended the complaint, stating that instead they were going to focus on the failure of Grindr to implement safety features in order to prevent this kind of thing from happening. The court didn't hold Grindr responsible for any of the actions that happened during this period of time, since they weren't directly responsible for the stalkers themselves. This is the most disgusting case that I've come up in my research, and determines that Section 230 is bad at determining one thing, and that's negligence. Being able to utilize Section 230 protections in order to lift legal liability from harm that is caused by the user base is something that shouldn't have even been possible, let alone common practice when it comes to Section 230 protections. Now, those previous cases were examples of a company protected under Section 230 since they weren't directly involved in the production of the offending content. But what if your website essentially required you to break the law in order to use it? Roommates.com is a roommate matching service that was found by the Fair Housing Council of San Fernando Valley to be basing listings based off of the protected classes under the Fair Housing Act, which included gender, familial status, and sexual orientation. The Fair Housing Council took Roommates.com to court, and after the case made it to the 9th Circuit of Appeals, Roommates.com were found to have no bearing under Section 230, since their websites required their users to identify themselves based on these protected classes, and the listings were sorted based on those protected classes. This case helps us illustrate the true limits of Section 230, which in order to get a conviction requires the entire website to be built around breaking the law. With that being said, I'd like to briefly look at the issue from the other side of the coin, in which I'll bring up the greatest argument for Section 230 protections, which is directly inspired by a case that was brought to the Supreme Court all the way back in 1959. A bookstore owner was arrested and held in jail for 30 days because he carried a book that was considered in the state of California to be obscene. This was only because the book depicted a sexually liberated lesbian woman as its protagonist. Oh, to live in the time in which we live. This case went all the way up to the Supreme Court, and they upheld that even though the contained speech wasn't constitutionally protected, the bookstore owner was not liable for distributing the content. Simply put, the justices stated that you can't expect a bookstore owner to screen every single book that comes into his store, since tens or hundreds of books are brought in every day. So if you agree with the ruling of the case, then it's easy to equate that to the over 9,000 tweets, 54,000 Facebook posts, and 147,000 gigabytes of internet traffic distributed every single second. To be frank, I'm not utilizing this case in order to justify the behavior of some of these companies. That being said, there isn't an easy way to sort through all of that information without either consistent checks by the companies, which would be nearly impossible due to the volume of data that's distributed every single second, or relying on an algorithmic AI to do it for you. And we all know how well that works out. YouTube. So that's the case law that's necessary to understand how Section 230 works.
That being said, there's been plenty of attempts to rewrite and reformat Section 230, since the people that wrote Section 230 had no idea the internet was going to turn out the way it is today. That being the case, most of the proposed reforms are stupid and I hate them. Let's go ahead and look at 4 specific ones that I feel you should be aware of. The Earning Act of 2022 does 2 different things. Creates a committee to come up with the best practices for preventing, reducing, and responding to online sexual exploitations of children. exempts Section 230 protections from any content that solicits, distributes, or promotes sexual exploitations of a minor. While that not might seem like a bad bill at first, the devil's in the implications. A huge critique of the original draft of the Internet Act was that it was a very anti-encryption. The Attorney General of that time was critical of end-to-end encryption, since it was a tool that was used by criminals to hide their activities from the government, as well as common people that just needed privacy. That being said, the new law wasn't really clear on end-to-end encryption. The executive order was released at the end of Donald Trump's presidency after Twitter added a blurb under his tweet that stated that his unproven claims about mail-in voting was unproven. Maybe Trump got cold feet about his upcoming election. Wonder why? But what would this world look like with this executive order enforced? I have no idea. There's text in here that imply that the FTC will have the ability to regulate and monitor websites that don't comply with this order. There's also a statement here that says a newly created government body will prohibit online platforms from engaging in unfair or deceptive acts or practices. Which, what does that even mean? All in all, the executive order failed right out of the gate. This is a proposed act that removes Section 230 protections unless they get an FTC immunity certification, which proves that they're not monitoring information in the politically biased manner. There's quite a bit wrong with this act, but its most glaring issue is vagueness. What is considered politically biased moderation? What would an action that reflects another candidate negatively consist of? Before supporting this law, you have to ask yourself these kinds of questions. Alongside the question, now would I be okay with the government deciding all this? Now, let's look at the final act. One that's clear-cut and stands for something they members of both parties can support. The Badass Act limits Section 230 protections on websites that use behavioral advertising. They define behavioral advertising pretty clearly, and they lay themselves out in a way that limits harm done to local businesses. I feel like this is a good first step into tackling the big data problem that we're facing. So if you hate overly targeted advertisements, email your representatives today. Section 230 is a very important protection to understand, and one of the most debated and important parts of the internet law as we know it. The law isn't perfect. In fact, as we have explored, it can be stated that it doesn't hold internet companies liable enough in regards to the protection of its user base. However, before we're able to change a law that has a direct effect on millions of people on the web, we should be hypercritical of every angle that we take and address the issues that are actually harmful to people that browse the internet every single day.